Good afternoon and welcome to the Beverly Hills Bar Association's presentation entitled Retaining Momentum in Civil Litigation Despite the Pandemic. This presentation is brought to you by the Litigation section of the BHBA and co-sponsored by the Mediation section. My name is Brian Bergman. I'm a member of the Executive Committee of the Litigation section, and I'm a partner at Bergman, Dacey, Goldsmith, where my practice focuses on real estate litigation for public and private clients. We have a very distinguished panel for today's discussion. Ricardo Echeverria is a trial attorney with Shernoff, Bidart, and Echeverria, handling insurance bad faith and catastrophic personal injury cases. Mr. Echeverria is a past president of the Consumer Attorneys Association of Los Angeles, and he has been named a top 30 plaintiffs lawyer and was named one of the top 100 attorneys in California by the Los Angeles Daily Journal. Tammy Godley is a partner at Paul Hastings in its Los Angeles office, who specializes in entertainment litigation and sensitive executive investigations. Her clients include NBCU, Warner Media and its various entities, Warner Brothers, Turner, HBO, and Warner Music Group. This summer, she also led the pro bono team that obtained expedited summary judgment and permanently vacated the Betsy DeVos rule that would have siphoned up to $1 billion of CARES Act funds away from public schools. And last, but certainly not least, is Judge David Cowan. Judge Cowan is the supervising judge for the civil division. Today's discussion is about how to keep civil litigation progressing despite the pandemic. Clients are hurting financially from the delays caused by stalled matters. Delays are causing cases to go stale, which can prejudice a case. We as a civil bar need to be creative in finding opportunities to incentivize resolution. And I believe today's discussion will help flesh out ideas on ways to get your cases moving. I'd like to first turn things over to Judge Cowan to discuss the current status in the civil courts.
All right, thank you, Brian and Ricardo and Tammy for joining me on this program, and for all of you out there listening in. This is a really important topic for myself and the court at this time, given what we're facing. And I wanted to sort of set the stage a little bit and ask you to consider some of these things that we're going to be talking about today, not necessarily for all your cases, but at least for some of your cases. And because we're all in this together, and we have to think long-term about our civil justice system and civil litigation, and making sure that we can continue to provide prompt resolution for our clients' cases. And so we have not, the pandemic has now been with us, unfortunately, for about a year, and it's not over. And even with more and more people becoming vaccinated, the comfort level of citizens coming in to serve as jurors, comfort level of people coming in, lawyers coming in, it remains to be seen when the pandemic will be over. And so with that backdrop, it probably won't become as a surprise to you, but it's important to emphasize that our inventories and caseloads at the court are escalating significantly, probably 20% plus in a typical independent calendar courtroom in Los Angeles County. And so inevitably, that is going to create delays in the hearing of your client's cases. The court is going to be determining how to prioritize which cases should go first. But there's a lot that we can do as that process unfolds. And in particular, I'm really excited to have Tammy and Ricardo's input into ways that lawyers can help the court and help your clients keep these cases vital. That these cases are vital to your clients, and just doing one more deposition or one more discovery motion is not going to allow these cases to reach finality, whether it's to get the case behind them or to get a verdict. Before I turn it over for more discussion, I just want to also indicate, because I think that there's a little bit of misinformation out there about jury trials at the LA Superior Court. Starting on January 4th, the court did resume the scheduling of jury trials. Of course, jury trials have not begun, but that doesn't mean that they almost have, we've had many situations, particularly in preference cases, where they almost did begin, but for settlements at the last minute. So, and sitting here in Department 1, I can tell you that cases are announcing ready to go, and they are ready. People have tried to settle and have not settled, and there have been exigent circumstances warranting the cases going forward. So the first thing I think it's important to say is that the court is open for business safely, and that it's not going to work for anybody just to say, we'll see you in June, we'll see you in August, we'll see you next year, because then the inventory is just going to mushroom. And so we need to think about those cases that can be resolved one way or another, which we're going to talk about now, so that we judges and juries do have the time to hear the cases that really need those kind of trials. There is not one court policy. Each judge decides her or himself what needs to happen in a particular case. So even if, for example, a case is continued, no surprise there, the real issue is the length of the continuance and what is going to happen during that continuance period. And what we're going to talk about is what you can do to keep your cases alive so that you can achieve what your clients want and end the uncertainty of litigation. So with those initial thoughts, Brian, give it back to you.
Sure, thank you, Your Honor. The first topic for the group, I think, should be alternatives to jury trials. So bench trials, arbitration. Ricardo and Tammy, do you have any thoughts on that?
Sure. Since I'm the plaintiff representative, maybe I go first. Generally speaking, you talk to members of the plaintiff bar, they'll always say that they want a jury trial at all costs. And many times that's true. But I think what this pandemic has forced us to do is to rethink that a bit, because I'm not saying that a bench trial is the right thing all the time. In fact, it may be the exception rather than the rule, but it is worth taking a careful look from the plaintiff standpoint at your cases and identifying perhaps there are cases that are amenable to resolving by way of a bench trial. Obviously, both sides would have to be comfortable with who the judge is. But also some of the things you're going to, take into consideration. If you have an elderly plaintiff who time is not on their side, you're going to have to consider issues like that in whether to waive jury and go with a bench trial. The other potential option, it's kind of a first cousin of doing a bench trial, is if both sides don't agree that the current judge is who they want to decide it, but they are in agreement that they're willing to do a bench trial. And again, it's not for every case, but if you can afford paying a retired judge to sit under, Section 638 reference, to have all the powers of the Superior Court to decide the case, and you have the resources, and it's the right kind of case where both sides are willing to do it, it's an option to be identified. So I don't think that you can categorically say that you need a jury in every case, because certainly many cases you do, but I think this forces us to rethink that and look at cases carefully and identify which ones might be well suited to be decided by a bench trial. The other thing that I would mention that I have been doing in the course of the past year is identifying cases where there is a critical issue that needs to be decided, or for example, it's kind of an all or nothing type of case. And what I have done in those is when we agree to either a 638 reference or an arbitration is enter into what's called a high-low agreement. And for those of you that don't know what a high-low agreement is that you agree on the parameters of the numbers, and that usually the judge doesn't know what those are, the person who's going to decide the case. But if, for example, you as the plaintiff exceed the high number, you're capped at the number that you agreed to. If, on the other hand, it's a defense verdict and you're below the low number, you've guaranteed the payment of the low number. And if the award is anywhere in between, the amount that's actually awarded will actually be paid. It's very effective in doing these types of arbitrations where both sides are able to hedge their risk, manage their risk, and you eliminate the worst case scenario for either side. And it also is a way to get a case to resolution, because guess what? When you're done with the arbitration, there's no appeal and it's paid. So that's the added feature I'm a big fan of doing. I've used it in other contexts, but in the context of what we're talking about, a bench trial or an arbitration, I think it can be very effective from the plaintiff's side. Again, not for every case, but I think what we need to do is look at our cases carefully and identify those that might be well suited for that type of approach.
Ricardo, real quick before we go to Tammy, there's a question. The question from the audience is, I've heard insured defendants are refusing to waive jury. Are you seeing that in your practice, since you deal with a lot of insurance companies? No, not necessarily. I have certainly had some where they have said, absolutely, we're not going to waive a jury. And then later on, we're going to talk about some law and motion practices, talking about issues under 437C. But I have had insurance companies willing to have key issues adjudicated that could resolve the case. But I've not had categorical resistance from insurance companies, but I can't say that there haven't been some where they just said, no, they're going to wait for a jury trial, and we're just going to have to wait it out until we can get an open courtroom. And Tammy, what are you seeing in your practice?
So, I think that the premise here is that jury trials are difficult to do in the time of COVID. So we want to see whether there's an alternative like a bench trial or something that the court can do that can move us forward. A lot of these things require agreement, so that's tricky. As the questioner raised, getting both people to agree, but certainly it seems that it would be worth the time, because it is, as we all know, it's a lot more expensive as things get drug on to come back, to put it aside, come back to a case, come back, put it aside, come back, or just the time. It makes for a more expensive case. So I think you need to sit with your opposing counsel and figure out if there's something you can agree on that will either tee up a key issue that will then set you up better for mediation. Or the other thing that I've had success with, totally unrelated to COVID, because often my clients don't want a jury trial, but is the equity first rule in California. So if there's an equitable claim that has been brought by the plaintiff, then you can move, so you don't need their cooperation. And the court is entitled to try the equity issues first. And if that resolves certain of the issues that would otherwise go before a jury, those issues are resolved. So it also then will set up, usually when you get to the end of the equity first part of it, and you get where this is all going and the parties figure out how to resolve the rest. But I would say that is a very effective way, if there's not any cooperation on the other side, to get to a bench trial. You can also determine whether there is, if there are particular issues that you can tee up by motion, either by agreement or through motion to have the court try, and by their discretion of managing their docket can try ahead of time as well, that sets up again, that mediation time. So, in terms of equitable issues, a lot of times if you have a breach of contract, they have an accounting. That accounting claim can then become the basis for a bench trial on that. Where there's an employment case, where there's a governmental immunity claim, and you can also potentially tee up the interpretation of contract issues for the court to manage. So then that will also help set you up for mediation as well.
I'll just throw in, kind of following up on those comments, it's that first, as far as Ricardo's, what he had to say, the judges are initiating and in the middle of a lot more bench trials, I believe, than perhaps was going on previously. And so that's very much started. So I think it's important that you talk to your judge at the next case management conference or other hearing to explore these issues. And as Tammy also indicated, it doesn't have to be the whole case. I'm a big fan of the teeing up, as it were, approach, because in every case, even if it's a pure jury case, there's still, that there are issues there that are legal issues or equitable issues. And if you start to think about your cases, I know when I was doing case management conferences, I would look to see, well, are there any equitable issues here? You'd be surprised how many cases, I was surprised how many cases did fit into that. Real estate is a common one. Partition actions, title actions, Tammy's already mentioned. Contract cases, at least to some degree, even if damages is something that would go to a jury. Interpretation of an agreement is there in so many cases. And the other thing I would also say is that we have a really talented bench in Los Angeles that I'm proud to be a part of and support. And our last couple of governors, have given us great people on our bench, many of whom have great civil experience. Others bring other terrific experience to sitting. We're all human beings, as it were, underneath black robes. I hope, and react to things, follow the law, and can serve as valid, impartial triers of fact. That's what we're trained to do. That's why we were appointed or elected. And I think that the bench is keen to handle their caseloads, and in the right case as they are already, spending a good deal of time doing these bench cases that can be a lot of work. Statements of decision and so on have to be drafted, but the LA court is rising to the occasion. And so I ask that you at the next hearing to explore what part of the case can we tee up so that the client's cases can move forward. Brian?
Your Honor, I'm going to paraphrase a question from the audience. Because there are less jury trials, is there any difference in how much motion practice that the judges are now handling?
Yes, I am frequently reminded by my colleagues that they are busy. And it's I forget what that aphorism is about. If you've got an empty space, it will fill. Is it Murphy's Law, or that if lawyers see an opportunity to keep a judge busy, they do, and you're all good at it, because everybody is saying how much more motion work is going on in the court. I know that when I was last year sitting in Department 20, it's amazing. I mean, you'd think I would have extra time because I wasn't doing jury trials, but many of these motions are difficult, and we write decisions, and they take time. Quality work doesn't come. I won't speak for myself, but we all try to put out quality product and deal sensitively with the issues that are presented to us. So we're busy, but we've still got a further job to do to bring finality to your client's cases. And so that's my job here, is to explore how we can do that on top of what we're doing already.
What does the panel feel like about virtual trials? Well, perhaps there still is a jury, but it's not in person. I guess I'll start with you, Your Honor. Is there has that been used so far in the civil division?
In the Los Angeles Superior Court, the court is not holding at this time virtual jury trials. That is not to say that perhaps they could not be done in the future, but there are a number of very significant constitutional diversity of the jury pool type issues, and making sure that we don't have a system where some people have to take the bus to come to the courthouse to perform jury service, and other people can do it in their home. So there's a lot of serious issues before that need to be worked out, if they can be, beyond just technology. I mean, LA can do what other places can do technology-wise and more, but we're not going to sacrifice the relevant considerations relating to making sure that there is an appropriate jury pool, and that everybody have the same opportunities to serve, that the litigants get a good cross-section of the population serving as jurors. So I don't want to be negative, but I do want to be careful.
And Tammy and Ricardo, how do you guys feel about the possibility of virtual trials? Something to avoid, something of interest?
Well, from my perspective on the plaintiff side, it's not something that would be my first choice. But like I said at the beginning, I never say never. There may be a case that might be appropriate for a virtual trial. But the concerns I have on the plaintiff side is, A, does the entire jury pool have the ability, technology, to serve as a juror? And what jurors am I losing as a plaintiff that could be good jurors for me just because they don't have Zoom and they don't have the computer technology? That's a concern. Another concern is, part of any kind of a plaintiff consumer case is credibility. And, you connect with the jury as the lawyer, your client, the witnesses, and I think you tend to lose some of that if you were to do it virtually. And of course, another concern is, will the jurors have their undivided attention on your case? We've been in this Zoom technology for a year now, and everyone's experienced it, where you get distractions in your home or whatever. And you're talking about, a jury trial where it's a very focused time to do. So I have a lot of concerns about it, but I don't categorically say no, because there can be a case. I'm thinking of a shorter case, a simpler case that might be amenable to doing it. But I've never done it, so I can't really express a strong opinion at this juncture.
And I think one thing we've found is that things we didn't think we could do virtually, we can. And in fact, mediations, I think we're going to continue to do them virtually in some instances going forward. I think people have had some good success with bench trials and arbitrations being virtual, where the technology is there for us to do it. I think the real question is if these issues that have been raised about a jury, does it make sense to do that? It probably depends on how long this goes on for and how difficult it is, how many of those trials get backed up. But for now, I think it's probably appropriate and most prudent to focus on those, the bench trial, the arbitration that can go forward in the virtual setting in a much more effective way, probably than the jury trial.
If I can follow up on that thought, is that if I was being cautious before, I'm much less so, and more of a booster, if anything, for virtual bench trials. And I can speak with some personal experience on that front, having conducted 2 significant ones and they went without a hitch. The lawyers did a terrific job in putting on platforms that were without any technical issues. As I understand it from them, they saved their clients money by doing it remotely. Nobody was, except me, wearing a mask because everybody else was remote, witnesses, clients, lawyers, and it was very efficient. The plaintiff side has told me that they also saved on experts costs. That would be true, I'm sure, for the defense side as well. An expert doesn't necessarily have to be brought from Texas or New York City or wherever for a trial, and maybe doesn't even have to be hired the whole day. And so we all know that expert costs can be significant, and I think in the virtual context, those are pared down significantly. I also think that from that with a virtual trial, there are, if anything, actually, like I'm sort of in your face right now, as it were. You can, for better or for worse, you can see, what the witnesses up close, what the witnesses, their expressions, expression of the judge, the lawyers, and the client's reactions to different things at the trial. So I don't, while we lose some things by not all being in the same room, I think it remains to be seen that you cannot put on an effective presentation virtually. I'd be interested in what Ricardo, Tammy, you have to say about that.
Well, I talked to my partner, Bill Sullivan, and then he with Tim Reynolds. They did one of those cases before Judge Cowan, and they felt very good about the experience. They invested in a concierge with the service that helped with all the technical stuff. So if something happened, there was someone there that both sides were paying for to help with those glitches. You want to make sure you're in a place where you have really good conductivity. They talked about how you might want to ask things like who's in the room right now, kind of setting your record since people are in different places. But all in all, I think they felt like the technology was there to get it done effectively, and felt like it worked out pretty well. So, so I think the vendors are quite up to speed with the things that we need to do.
Yeah, in terms of virtual bench trials or arbitrations, I think that is a good idea. I actually have done a couple of arbitrations by Zoom, and they were both very seamless. The technology was there, and it worked out really, really well. As I said on the prior comments, that's more about bringing the jury in. That the jury's out for me on that, but we'll see.
All right, our next topic is what we've called jury trial, but different. I know when I've been in court, I've been encouraged by many judges to stipulate to smaller jury pools. And so that's our first discussion. What about alternative size juries?
All right, so to the extent things do improve in the spring, which I certainly hope, and in the summer, and we do ramp up as anticipated to having jury trials in the courthouse. I think that social distancing will remain to make sure that people feel safe and are safe. And so I think that an important discussion that is already going on with those preference trials that I mentioned already is who's going to sit where. The jurors are not going to be in a jury box. They're going to be spread around the courtroom. And so for those people out there listening in who plan to do jury trials soon, you need to start really thinking about setting what the stage is going to be for that jury trial. Where are you going to stand? Who's going to be with you? does this quote second chair really have to be in the courtroom? We're going to have with those things on the walls which say maximum capacity. That's in the old days. It's now going to be how many people can. It's going to be radically reduced. So there's a lot of hard thinking that is required both of the judges and the lawyers relating to how we're actually still going to do this. So that's, I think, important point number one. The second is that, as has already been mentioned in part, longer trials are going to probably present more problem than shorter trials. What happens if you're in week 2 and a couple people get sick? Is all that time going to be wasted? What agreements have you worked out ahead of time for perhaps the remaining number of jurors still being able to decide the case without the full 12? Would you agree that the judge could decide the case if a certain number of jurors fell ill? These are things you really need to think about ahead of time to avoid catastrophic waste of time and money. In addition, as Brian indicated, there's also an issue about whether or not you really need 12 jurors. Of course, you're entitled to 12 jurors, and nothing I'm saying here in terms of alternatives should be read to imply that the court does not want that people have their rights to a full jury. The question is whether there might be alternatives that people might think about. And so federal court certainly has less than 12 jurors. By stipulation, there can be a lesser number of jurors, and that might be something you want to consider. Ricardo?
Yeah, on this subject, I actually have had 2 jury trials in person in the last year during this COVID pandemic. And I guess the best way to tell you kind of the issues is to walk through some of the issues that we actually faced in those 2 cases, because they bring to light some of the comments that you're bringing about, Your Honor. I mean, the first case I had, actually, just looking at the date, March 2nd, it was a year ago today that I started jury selection on that case up in Yolo County. And long story short, we finished 2 weeks out of a 3-week trial. And then March 16, the court informed us that the courthouse had to shut down. And rather than declare a mistrial, the short story is that 12 of our 14 jurors agreed to come back 3.5 months later on June 29 to finish up the trial. And we did. We finished up the trial, and we got a verdict just after the 4th of July with the last 12 remaining jurors. But to put a little more meat on the bones there, when we did come back in terms of social distancing, yes, we, instead of 12 jurors in the box, we had 6 in the box socially distanced, and the other 6 were behind the plaintiff side in the gallery socially distanced. And the gallery behind the defense had 6 available seats, and those were divvied up, 3 for the plaintiff, 3 for the defense. So I was up at counsel table, and then my second chair was in the gallery in one of the seats, and my IT person was the other person. And then one of my clients sat in the other chair. So you had the ability to have, a client watch the proceedings, et cetera. The other thing about that case that was unique is that it was live streamed on YouTube. And so the significance of that was I had a rebuttal expert in Seattle who had testified in March, but I got a little leeway that because we were just going to now try in the defense medical issue on the damages here now, 3.5 months later, he allowed me to bring my expert back in to have some rebuttal comments. And he was able to listen to the entire proceeding, and it was seamless because then we just brought him in, and we could have done it by Zoom, but we did it by telephone, and he testified telephonically to the jury. But that was all possible because he heard in real time the proceedings back from his office in Seattle. And the other issue there, and this really is going to depend on county to county, because this was a big difference between that case and I'll tell you about the second one. Yolo County allowed us to wear face shields. And in fact, our judge encouraged it. And so I made the executive decision to bring a whole bunch of face shields individually wrapped, and we made them available to jurors if they wanted it. We obviously told them it was from the parties. I gave them to the defense team as well. So everyone was wearing shields. I mean, we looked a little ridiculous, but they could see our expressions, and we could see the jurors' expressions, and we could see the witness expressions. And during closing argument, you could definitely get the benefit of that with those that did wear the shields. Now, in contrast, the second case I did was just recently in November, was in Orange County, and it was an in-person jury trial. And obviously in the first one, we didn't do jury selection, which would have been a real challenge to do that socially distanced. We were dealing with 12 jurors and we could manage them socially distanced in that courtroom. But Orange County, now we had to pick a jury. And to start off with, it was a short trial. It was only 3 to 4 days, but Orange County was triaging which cases they could get out. So one was they were looking for the shorter trials. And number two is both sides agreed to a jury of 8, and it was 6 out of 8 for a verdict. It's the same ratio as 9 out of 12. So I do recommend that, because here's where it comes into play, especially in jury selection. In the courtroom that we were in Orange County, we could socially distance 18 prospective jurors at a time. And we had a panel of about 40. That means the other remaining 20 or so jurors are out in the hallway. And unlike YOLO, Orange County did not have live streaming. So those jurors sitting out in the hallway had no idea what proceedings were going on. And the reality is, by having only 8 jurors and each side having 4 peremptories, we were able to get a jury picked from that first panel of 18 with just 1 prospective juror left. That would have been impossible if we were going with 12 jurors and 6 peremptories each, because then what would happen is when you run out of jurors that are in the courtroom, you kick everyone out and you bring the new batch in and you start all over again. Start with a mini opening, introduction of witnesses. And they warned us that it might take 2 or 3 rounds of that to get it done. But the reason we got it done in 1 round was because we stipulated to a jury of 8 instead of 12. And 4 peremptories instead of 6. And ironically, each side only used 2 peremptories. So that was an issue. The other thing that was a big contrast, and this is that Orange County did not allow us to wear face shields. We had to wear a face mask. And I think that's going to depend county to county. I think it just depends on what county you're in, if they'll allow you to wear a shield versus a mask. And it was strictly enforced. The lawyers, the entire time we wore a mask. And the jurors the entire time wore a mask, which for jury selection was quite difficult, because you can definitely hear what witnesses are saying, but you can't read their facial expressions unless they're openly nodding their head or shaking their head. It's hard to read. And so the philosophy I had is, we had to go in every day and act like we're ahead and just keep going for it, and trust your judgment. What we did do in that case, though, Orange County courtroom was set up where the witness box was surrounded by plexiglass. I mean, it would look like a hockey penalty box. So when the juror got in there, the witness got in there, the judge would ask the witness to take off his or her mask. And so that way the jurors could at least evaluate the credibility of the witness without the impediment of a face mask. And then the last thing I'll say in both cases, in terms of practically speaking, that the jury room was not big enough to socially distance 12 jurors, or in the other case, 8. So what we did in both cases is, once we were done with closing arguments, we had to lickety split clear the courthouse, and the courtroom was then the jury deliberation room for the jury. And the only rule in both cases was you can't sit on the bench, but you can sit anywhere else. And those are some of the practical considerations we had to do an in-person jury trial that I found significant.
And Tammy, for your practice, how do you feel about alternative size juries? 6 out of 8 or unanimous 6, anything like that? I
think it's certainly worth considering. I have not utilized that so far in my practice, but it's certainly worth considering in these different times. So I wouldn't say never. I would never say never.
One thing I would add, Brian, to that, and this was again just, you have to think a little outside the box in these times. And when we were dealing with the first case up in YOLO, we were coming back June 29. We were probably one of the first cases to be in person at that time. And here we'd spent 3.5 months hiatus, and we got the closings done. The jury got the case right before the 3-day 4th of July holiday weekend. And, you're always worried at 3-day weekend, what can happen? I mean, on the other hand, we just went to 3.5 months. What's a 3-day weekend? But just to give you an idea, what we did agree to, the plaintiffs and the defense lawyers, is that if our 12 jurors, we had no alternates left, if we lost a juror over the weekend or even two, we stipulated that on Monday, if we had less than 12, we're going to put the remaining names in a hat, pick the first 9, and that'll be our new jury. And it'll be 7 out of 9 for a verdict. And the remaining 1 or 2 will now be alternates. We didn't have to use that, but it just was going to be a crying shame to have gone that far and to now have a mistrial, perhaps because we lost 1 juror over a 3-day weekend.
I would just say in Los Angeles, masks are required, not shields. And so that is something to think about in terms of if you wanted to have a jury trial in Los Angeles. The concerns Ricardo raised about not being able to see facial expressions, both of jurors and witnesses, will apply. And so I think that makes even more important what we're discussing in terms of alternatives. Also, I know in working on some trials that we're about to begin that the jury selection process in this context is very challenging. How a particular judge in Los Angeles chooses to do it remains to be seen. Each person will figure out what works for them, but the days of a jury assembly room certainly are gone. That's not going to happen in Los Angeles. But whether you how many people you bring in at a time is really going to be the issue, and how much needs to be repeated for each batch. But just like in pre-COVID, where jury selection could sometimes be longer than a trial, I hate to think what it could happen now, depending on, some people are better at jury selection than others. There's quite a lot of latitude that's allowed under the recent legislation for jury selection in civil cases. So let's talk about, Brian, why don't we perhaps go to some of the other things that we wanted to talk about as alternatives.
Sure. Well, I've got a question from the audience, if you wouldn't mind, Your Honor. Are witness boxes shielded in plexiglass?
I should know the answer to that question. I believe they are. Yes, I think that certainly between the bench and the witness, and as I believe also between the witness stand and the jury box. Again, Los Angeles has hundreds of courtrooms, so whether that's true in all of them, I cannot sit here and say, but certainly the court has invested significant sums in putting up plastic screens to mitigate risk throughout our courtrooms and the courthouses.
In a similar vein, another question is, how long do you anticipate that pandemic restrictions will remain in place now that vaccinations are becoming more prevalent?
Well, I know that I'll just say this. Have you heard any politician answer that question, or somebody who is responsible for the pandemic? If they're not able to do it, I'm not sure how fair a question it is of me to ask of me. Certainly, it's a legitimate question. People want to know when we're going to get back to normal, but I think I'm not going to risk having egg on my face on that one. I think that certainly the court hopes, like everybody, that gradually things are going to improve this year. But with the issue of variant types of the virus out there, and even without those, I haven't had my vaccination yet. I'm an essential worker. And I've been coming to the courthouse, all year during this pandemic. So if we think about the rest of the population, notwithstanding the considerable efforts that are being made to vaccinate people, it's going to take time.
So our next topic is, and we've touched upon it already, the increased use of motion practice, but I know the panelists want to get into some specifics as to how you can use increased motion practice to move your case along. So Ricardo, Tammy?
Yeah, I mean, from my perspective, one of the things that that we've done is if you have a case where motions in limine are going to, really either change the complexion of the case, whether certain key evidence comes in or doesn't come in. It's not in every case, but we've all been there where you got a case that maybe has 30 motions in limine, and by the time you're through all of them, the case you thought you were going to try on day one is not the case you're going to try after motions in limine. And I think what's helpful to do in those circumstances, again, you have to identify the case, is try to find a way, if you can, to stipulate to have the motions in limine heard, even if the trial is 2-3 months away, have the trial judge hear the motions in limine, because if you can do that, then there's a chance that it may also help you resolve the case, depending on what the rulings on the in liminis are. So that's point one. The other thing that I see quite frequently in my practice, because I do both insurance bad faith and catastrophic injury cases, is, you may have a case, a catastrophic injury case go into trial that has a verdict value of X, but the real wild card issue is there's a minimal policy. Maybe it's a 15,000 policy or 100,000 policy, and there's a dispute about whether that policy has been opened up. In other words, was there an opportunity to settle within limits, and did the insurance company fail to accept a reasonable settlement demand? And what I have had success in doing in terms of resolution is work with the defense lawyer and the insurance company and say, look, at some point this issue is going to get decided, but it's not going to get decided until the second bad faith case. And so why don't we try to work out a resolution where we have cross motions for summary judgment on the issue of whether the insurance policy is open. And you take all the risk factors into play on the underlying injury case, the risk factors of that case, the risk factors of the insurance case, and you establish parameters of a high-low, like I talked about earlier. And so the judge is going to decide this discrete issue of whether the policy is open or not. And if you win as the plaintiff, you get the high number. If you lose, you get the low number. But it's a way to get a case to resolution and to facilitate that, because, and I just did this, I filed the motion yesterday using this exact section. Under, many people know, if under 437C to bring a motion for summary judgment or adjudication, yet if it's an adjudication motion, it has to adjudicate an issue of duty or an affirmative defense or a cause of action. And when we're dealing with these types of cases where it's whether there was a breach of the duty to settle, and everyone knows there's a duty, the question really is whether there's a breach. It doesn't fit neatly into that mold. But what a lot of people don't know is that there's a section under 437C, in particular subsection T as in Tom, that allows the parties to stipulate to have a legal issue decided by the judge, or an issue of damages, not including punitive damages, even if it doesn't meet the requirement of adjudicating a cause of action, affirmative duty, affirmative defense, or an issue of duty. And the way what you have to satisfy is to establish that resolution of that legal issue or issue of damages will either promote judicial economy by either decreasing trial time or increasing the chances of settlement. But in my world, where we're dealing with consumer cases and there's insurance policies to defend the defendant and issues of whether that policy is open or not, it really does lend itself well to a win-win situation, because both sides save the expense of having to work up the underlying case, and you get the final resolution by getting it decided now rather than perhaps 2 or 3 years from now. So that's, again, it's not for every case, but it certainly works in cases where it's an extreme all or nothing type of situation. Both sides can hedge their risk by doing a high-low, and in particular when it's tethered to a key legal issue, you can tee it up, as Tammy and the judge said, by way of 437C, T as in Tom.
The only thing I'd add to that is that I think sometimes judges are reluctant to hear motions in limine before trial because of a variety of efficiency reasons, or back when in prior times. But so it's important to explain why, like how this is going to move the ball forward because they may have pre-existing ideas about how, no, let's keep this efficiently right before trial. So make sure you're clear to the judge why this will help move things forward, so they're maybe more amenable to motions and maybe significantly before the start of trial.
And one thing I'd like to add on this subject is CCP 599, which continues trial-related dates with the trial. It was enacted during the pandemic for obvious reasons. But if you read the section, it also provides, unless the court orders otherwise. I've heard from quite a few lawyers that perhaps it doesn't make sense in all cases to push the expert deadlines with the trial date. There's obviously a lot of work that can get done now on experts, even if you're not going to have the trial immediately. So I think it's worth considering whether under 599 you want the court to order otherwise and say that the expert deadline should not track the trial date. I know some will say, well, we're going to run up a lot of expense now. Well, then maybe that's an issue for settlement, that you're going to otherwise have to spend a lot of money. It's also going to be, however, also be an opportunity to better evaluate the case. Judges are told all the time, well, we don't know what the case is really worth because the experts discovery hasn't been done. Well, do the expert discovery and know that, even if the trial is not going to follow immediately, if that's what it's going to take to evaluate the case, then it needs to get done, or may need to get done in a particular case. I don't know if either of Ricardo or Tammy, what your views are about that.
Yeah, in my practice, where that really comes into play are on cases that are very expert dependent, and I'm thinking of catastrophic injury cases involving a brain injury or quadriplegia. I mean, those cases, you have on each side probably 7 or 8 different experts, many physicians, life care planners, economists. And if you follow the standard CCP rules, you're basically double tracking depots for the month before trial, trying to get them all done. And if you know that that's what you're going to have, and you know that that's going to be necessary to the proper evaluation of the case, that's where I think you give yourself a cushion and do the expert witness discovery first, because then it gives you some time, A, to do it comfortably, and then to evaluate the case after you hear what each side's experts have said. I know there was one county that I remember that actually set expert designations much more generously than the CCP allowed. But that's something that I think is a very practical discussion you can have with the other side, because it benefits both sides to me.
Yeah, I mean, I think with each case, that whether or not it makes sense to keep your deadlines, to keep on track, to get it kind of put in a can, or whether it makes sense to put it off. I mean, one of the things, as we all know, as things get extended, it costs more money. And so that's, the financial part of it you want to be thinking about. But then how is that going to impact your ability to put together your case? I mean, I think it's just in each case, it's something we haven't thought about before, so we need to add that to our, do we want all the dates to slip, or is there a reason to keep them forward, and is it going to be most cost effective to not have them extend with the trial date? So I just think it's case by case.
One thing I'd like to bring up before we run out of time is settlement conferences in the LA Superior Court. Department 1, before it sends out any case for a jury trial, is generally requiring, in most cases, that there be some form of settlement conference within the last 90 days. Not a year earlier, 90 days earlier, whether that be with a judge, private mediation, or otherwise. But Department 1 is not going to bring in prospective jurors if it's not satisfied that people have tried to settle the case on their own or with with some assistance. I think it's only fair. So Department 1 will provide mandatory settlement conferences with sitting judges on cases that are otherwise about to go to trial, if you haven't had one within the 90 days. In addition, we continue to have our excellent MSC unit at Spring Street that is doing remote settlement conferences. And we have judges around the county who are actively settling these cases. So again, as we've discussed, get your case ready so it can be evaluated. We all know that the clients really appreciate the opportunity to sit in front of a sitting judge or retired judge or other mediator to hear what somebody neutral has to say about the case. It's not the same as a bench or a jury trial, but it is an opportunity for somebody to tell their story and to a neutral and have that person say, that doesn't make sense. You're going to lose. You're going to win. That's only worth blank. Whatever the particular settlement officer's style or approach to settling the case may be. But in these difficult times, judges do not like hearing, oh, we didn't think about doing that. If anything you take away today is you need to do not go in front of a judge and say you've not thought about settlement. You're not doing it, in my view at least, you're not doing your clients a service if you're not saying settle every case, but at least give them the benefit of having that input. But I turn it over to the others on that issue.
Yeah, I mean, in terms of settlement, I think every case should go through an opportunity to try to resolve it. And not every case settles, but every case should go through a good faith effort to try to resolve it. And I think the more creative you are on some of these things we've been talking about, the better chance you're going to give yourself to settle a case. At the end of the day, I mean, what drives a settlement is motivated parties. Certainly having courtrooms available helps a tremendous amount, but I've been pleasantly surprised on some cases that were resolved because the parties were motivated, even though our trial dates were not off. That's not to say in every case. There's certainly some cases that it's going to require a trial date that is a real trial date to really have a chance of settling, but that's not the blanket rule. There are cases that can be resolved now through motivated parties.
Yeah, and I guess I think this is always true. It's always good, as the judge said, and as Ricardo said, to try and settle. This is just an additional factor that comes into the mix that, okay, when you want some kind of resolution here, we're talking 3 years out, or we're talking, who knows? Actually, on some of my cases, who has any idea at this point? So then that creates some momentum for settlement that adds to the overall mix of factors. And I think we've seen that mediation works well by Zoom, and that if you can get quicker resolution that way, parties are really considering that anew and with increased enthusiasm when things are so uncertain in the future.
Well, I want to thank all of you. We've reached the end of our 1 hour presentation. This was a great discussion on ways to keep civil cases moving. I'd like to advise the audience that this presentation is good for 1 hour of MCLE credit, and you should receive an email confirming your MCLE credit within 24 hours. So thank you everyone again for joining the presentation.
Thank you very much. Nice to see everyone.
Bye.